Hello, Assalamu alaikum, good evening. Welcome to the Ask Aman live stream. This is Aman Solicitors. Sorry, 1 second, if technical problem. Thank you very much for joining our live stream this week. We will be discussing a number of matters today. Before we go on to the live stream and to discuss the relevant matters, I'm just going to play a couple of videos. The first one is welcome back. Thank you very much for that. And before we go on to the first feature, just a promotional advert.
Aman Solicitors Advocates. From our offices in London and Luton, we represent clients across England and Wales. We specialise in civil and commercial law and litigation, divorce, child custody, contact and family law, all areas of personal injury, accidents at work, trips and slips, family and business immigration, nationality, asylum, deportation and detention law, wills and probate, employment law for employees or employers, charity law and disputes, public and regulatory law. Our professional and committed legal team will provide you with a first-class and competitively priced service. Aman Solicitors Advocates, your firm of choice.
Welcome back. So this week we'll be, as ever, going through a number of issues. You can all, of course, post your questions and comments onto our live stream on YouTube and Facebook, and we'll try and answer them if they're relevant to the subjects we're discussing, or even general questions or comments will be taken if we can answer them today. As ever, just to remind you that the advice and guidance we give is for general information only. In relation to your own personal work or cases, you must take professional legal advice from a competent and professional solicitor, so that you and your work are done in accordance with the requirements of your particular case, because all cases are different, and trying to do a cut and paste job can be very dangerous and often can be fatal in some cases to your legal case and chances of success. So we'll be starting with our employment law feature. My colleague Saad Saeed, I'll welcome him on board. Assalamu alaikum, Saad. Thank you very much for joining us.
Wa alaikum assalam, Mr. Bashar. How are you?
Very well, Jazakallah, thank you. And it's over to you, Saad. I'll make myself scarce.
Thank you. And good evening to everybody that's watching. Okay, so today I'm going to be talking about the concept of dismissing somebody because of capability. This is the second in a series of lectures. And previously I spoke about the 5 reasons where an employer can fairly and legally dismiss somebody from their employment. And I talked about conduct previously, so today we're going to be talking about capability. Now, when we talk about capability, essentially what we're talking about is whether an employee is capable of doing the work that he was actually employed to do. And therefore, if the employee is actually incapable of doing the work that he was actually employed to do, potentially an employer can fairly and legally dismiss that employee for reasons of incapability. When we talk about capability, we're talking typically about things like the skills of the employee, the aptitude of the employee, the qualifications of the employee, maybe sometimes some other physical or mental qualities, or sometimes even the health of the employee. And generally what we're talking about is when we look at these factors, then the employee is incapable of doing the job that they're employed to do. So as I said before, if the employer believes that the employee is incapable of doing the job that they are employed to do, they are legally and fairly allowed to dismiss the employee, but provided only that when dismissing the employee, they act reasonably in doing so. So it's also important that the employee is dismissed because of the work that they were employed to do. So there actually has to be a link between the incapability and the dismissal and the work that they have to do. If an employer was to find somebody was incapable of doing something they weren't employed to do, that wouldn't necessarily allow them properly and legally to dismiss somebody for reasons of incapability. As I said, an employer must always follow a fair procedure when deciding to dismiss an employee for reasons of incapability. The approach to a fair procedure varies depending on whether the employee is incapable due to incompetence, so things when I said about skills, qualifications, aptitude, or whether the employee is incapable due to sickness. So we're going to look at both of these one by one. Let's look first of all at incompetence. So we have a scenario here potentially where an employer has taken somebody on board to do various jobs, and they have a feeling because they have a lack of skills, because they have a lack of qualifications, or a lack of aptitude generally, then they are incapable of doing that job. So when it comes to following a fair procedure for incompetence, it's important for employers to follow the ACAS code. The ACAS code on poor performance and incompetence suggests the following procedures that an employer should follow. So first of all, it's important for the employer to actually meet with the employee, discuss their poor performance, potentially give them warnings about their poor performance, and also to give them an opportunity to improve. Now, if appropriate, in terms of giving the employee an opportunity to improve, the employer should give further training to that employee. And that training should be adequate. So it can't just be any old training which will not help them in carrying out the work that they were employed to do, but must be adequate training tailored to their needs, preferably. The employer should also set periods of review where they can come back and revisit the poor performance of the employee or monitor it, so that a timetable can be set in place to see whether the employee is actually responding to the training and therefore improving and therefore showing that they are capable of doing the work. And in some cases, the employer should consider whether it's actually possible to move the employee to a job that is actually within their capabilities. So, for example, if you had previously moved that employee from a job to another job, and in that new job they were incapable of doing it, then they should give serious thought and consideration to moving them back to the old job which they were capable of doing. Now, when we talk about capability, it's always important to take into account the length of service that the employee has. And generally speaking, the longer the length of service, the more the duty the employer will have to make sure that they give adequate warnings and give further trainings and give them chances to improve. And that's really a matter of common sense, because obviously if you've had somebody who's worked with you for 10 years or for you for 10 years, as opposed to somebody who's worked for you for only 1 year or a few months, the employee who has worked for you for 10 years will be more valuable than the one who's worked for you for a much shorter period of time. So that's generally what we look at when we look at adopting a fair procedure when it comes to incompetence. And at the end of the day, if the employer has given the employee every opportunity to improve, an opportunity for adequate training, if they have monitored their poor performance or their incompetence, and even looked at alternative employment, but ultimately the employee does not improve and remains incapable of doing their job, then generally you would say that the employers followed a fair procedure and they will be entitled to dismiss the employee for reasons of capability. Now let's turn to sickness. So as I said before, sickness can also mean that an employee becomes incapable of doing their job. Now, when we talk about sickness here in terms of capability, it's very important for people to understand that there is a very thin line between somebody not being able to do their job because they are sick, and that sickness meaning that they may or may not then become a disabled person. I'm not going to talk today about people who are so sick that they are considered disabled people. Those people are covered under the Equality Act. That will be a talk which I will do on another day at some point in the future. So everybody who's interested, watch out for that. What we're talking about here is people who are generally sick and incapable of doing their job because of general sickness, but it doesn't amount to a disability. Okay, so sickness can sickness can fall not only within the scope of making somebody incapable of doing their job, but there's also a fine line when it comes to misconduct, because sometimes general sickness or unrelated periods of absence or of sickness continuously can mean that a person has a poor attendance record, and that would then fall into the realms of dismissing somebody for reasons of conduct as opposed to incapability. And it's important for any employer to know whether they are actually going to be dismissing that person for reasons of capability or conduct, because of the differences between them. There's different procedural considerations between the two reasons. So let's assume then that somebody is sick and the employer is considering to dismiss them for that reason. They're not a disabled person, and we're not talking about conduct issues. So, as I said before, by law, an employer can fairly dismiss someone if they have a long-term sickness that makes them incapable of doing their job. But before the employer goes ahead and makes any such decision, it is important that they consider certain factors. What are those factors? Well, first of all, the employer should consider the nature of the illness. The employer should consider the likely duration of the illness. Again, the employer should consider the length of service of the employee, and the employer should also consider its own business needs. These factors are self-explanatory. Okay, and in essence, the reason why they're important is because they can make a difference to whether the person is actually incapable of doing their job due to sickness or not. Take, for example, the nature of the illness. Well, if somebody has, a most relevant example is if somebody catches COVID, but not seriously, and they may be off work for 7 to 10 days. Okay, then for those 7 to 10 days, while it is true that they're incapable of doing their job because of sickness, they would be expected to return back to work after they recover, after a short period of time, and be able to resume their job. In those circumstances, taking into account the nature of the illness, the likely duration of the illness, and other factors, it's highly likely that an employer would not be entitled to dismiss for reasons of capability. However, let's talk about if somebody was to get long COVID. So somebody was sick for a period, they contracted COVID, and initially they had it very bad, but then there were ongoing symptoms going on for many, many, many months. And these symptoms were preventing the employee from doing the job. And let's say, for example, it's been a year now, and the employee hasn't been able to return to work because of varying symptoms due to COVID. Well, taking into account the nature of the illness there and the likely duration of the illness, we're getting to the side of the scale where an employer can start thinking about dismissing for reasons of capability. But it would obviously be important to take into account how long is the illness more likely to last, and whether the employee can be expected to return to work within a short period of time or not. I said before as well that the needs of the employer are also something to be considered. Why? Because, well, a large employer who is able to replace the person who is away sick with another employee to cover their work may not need that particular employee back for quickly to do the work. They may be able to account for their absence, whereas a smaller employer with maybe a handful of employees may need that person who is off sick to do the work, and there may not be anybody else to replace them. And so the effect upon the business would be so much more than a larger business who would be able to cover for them. So like I said, all of these factors can be taken into account. And I would say that if the nature of the illness is so severe that it prevents the employee from doing the job, the likelihood of the duration of the illness is going to be long term and there's no prospect of recovery. If the length of the service of the employee is not such that in itself it would mean that you should keep hold of the employee, and if the needs of the employer are such that they can't continue without that person, so they need them, then generally you would say that the employer has grounds to dismiss the employee for reasons of sickness, and so because they are incapable of doing the job that they were employed to do. But the overall test, when we look at all of these factors, the overall test that the employer has to apply and meet in deciding whether to dismiss is whether the employer could reasonably expect it to wait any longer for the employee to return to do their job. And therefore, we don't have a one-size-fits-all scenario for all employers. It will be fact sensitive according to these factors which I've outlined. There could be other factors which may apply, and there will be different outcomes in different scenarios. But employers should understand that, as I said, the overall test is whether it's reasonable for the employer to be expected to wait any longer for the employee to return to do their job. If not, like I said, the employer will be entitled to dismiss for reasons of capability. But remember, even in this situation where an employee is off sick, a fair procedure must be followed. So for all of those employers out there, what should a fair procedure look like? Well, again, we would expect an employer to consult with the employee concerning the nature and the likely length of the illness. Some employees I know have trouble or difficulty contacting their employees while they're off sick, but it is something that can be done and indeed should be done. And in a suitable way, a consultation of some sort should be carried out. The employer should also seek medical advice relating to the condition of the employee so that they understand the condition fully. Again, as with incompetence, they should consider whether there is suitable alternative employment available and which can be offered to the employee who is off sick. But in cases of sickness, warnings are not normally appropriate unless there is a situation where the employee takes lots of short breaks for illnesses, which are different illnesses for different reasons. And in that case, the employee could be warned about his attendance record as opposed to being off sick. As I said before, once this fair procedure is followed out, so imagine you do the consultation, you seek medical advice, you do consider alternative employment, but there is none available, then the employer will be entitled to legally and fairly dismiss the employee for reasons of capability, because the employee has become so unwell that they're incapable of doing their job anymore, and the employer is entitled to dismiss. Now, also during this procedure, whether the employee is incapable of doing their job for reasons of incompetence or for reasons of sickness, there may well be disciplinary action where the circumstances around the employee's incapability are looked at. Employers should always remember, in order to follow a fair procedure, they must inform the employee that they have a right to be accompanied to any disciplinary meeting, or indeed they should even allow the employee to be accompanied to any investigatory meeting that may lead to a disciplinary meeting. And they should always allow that right to be exercised as well. By law, an employer is only the employee is only entitled to be accompanied by a fellow colleague or a trade union representative. However, in some small companies or organizations, there may not be a fellow colleague, or there may be very few fellow colleagues. There may not be any trade union membership available either. And in those circumstances, the employee should be aware that if the employee asks for somebody else to accompany them, as long as it is a reasonable request, it ought to be allowed. I would stress at this point that employers don't have to allow anybody else, but because we're looking at reasonableness and whether a reasonable and fair procedure was followed, in some circumstances it would be reasonable to allow somebody else to accompany the employee. Right, so let's assume then that the employer goes ahead and dismisses the employee for reasons of incapability. Employees should be aware that they are allowed to request from their employer, within 14 days of being dismissed, a written statement of the reasons for their dismissal. Normally and typically this would be a letter setting out why the employer has made the decision to dismiss for reasons of incapability, and should give adequate reasons. In fact, the employer should give all of the reasons why they have found the employee is incapable of carrying out their job, so that the employee knows exactly where they stand and why they've been dismissed. However, employers, be aware, if the employee subsequently makes a claim to the employment tribunal claiming that they have been, for example, unfairly dismissed because of their sickness, then that letter that you have sent them setting out the reasons why they have been dismissed is admissible as evidence during the tribunal proceedings, or indeed any other proceedings that may arise. So anything that employers do write in that letter, they should ensure that it is accurate and truthful, so that when it comes to further court proceedings, they are not caught out or it doesn't go against them. So, viewers, that is a general overview of dismissals and the law surrounding capability, and whether an employee can be dismissed for reasons of capability. As I said before, just to review, capability sometimes overlaps with conduct, but falls mainly into two categories. One is whether the employee is incompetent. The other one is if they are incapable because they are sick. And in both cases, there are various factors to be considered and a fair procedure to be followed. And if those factors are all considered properly and adequately, and a fair procedure is followed, then employers should be on strong ground in terms of legally and fairly dismissing the employee from work. I see Mr. Basharat is back. Thank you, Mr. Basharat, for letting me go through this with the viewers. As always, if there's any questions, put them on the chat or send them to us during the week, and I'll be happy to answer them.
Thank you very much, Saad. Stick around. We'll go through some of the issues shortly. So coming back to the next subject, which is going to be visit visas and challenging those. Last year, because of COVID, pretty much nobody could invite any relative or friend to visit the United Kingdom, whether it was for a wedding or to sightsee or otherwise. Now, I wanted to say a few words about visit visas for the purpose of tourism, because there are many other categories of visit visa, which may be relevant, for example, business visitors and so on. So with a visit visa for the purpose of tourism or family visits, as always, you have to apply to the relevant visa office of your country. Now, most of this, of course, is all done online, except one or two exceptions. And you need to complete the application form and provide all of the mandatory documents either by scanning them up or taking them with you. A few simple points to remember, because the visit visa applications will fall into a number of categories. Firstly, a straightforward one, you're a first-time applicant and you want to visit your family members in the United Kingdom. So with first-time applicants, there is no previous history to go through. You make sure everything is accurately put in, and you've got to show that you're a genuine visitor. You will be able to pay for your journey to and from the United Kingdom, that you will not break the laws and rules of this country whilst you're here, and that you will return at the end of your visit back to your country of origin. And of course, that you're a genuine visitor, somebody who is visiting to see friends, family, and tourism, and not coming here with any other purpose. Now, of course, suitability requirements do come in. So if you've got criminal convictions either in your home country or elsewhere, they will be relevant and may well be a reason why you might be refused. If you get past that, then it's important to get the documentation. And the documentation typically will be proving what you do in your country of origin, i.e., what are the factors that will take you back to that country? Because as a visitor, you have to prove that there is an intention to return, and that you need to show that you've got a reason to return. I mean, it may sound ludicrous that people are viewed with suspicion or skepticism, but that is the way these things work. So typically, proof of your work or your assets or your savings, your relatives, your family members, particularly a partner, a wife, and children, and so on, need to be provided. All documents not in English must be provided with certified translations, and you need to explain why you are visiting. Now, if you're earning very little in terms of sterling and you are spending your entire savings or a substantial proportion of your savings on a visit, that may cause people to ask questions, particularly visa officers. So what you must do is to be clear that you can justify and it's reasonable that you would spend that kind of money if you're funding it yourself. Typically, of course, or very often, a UK relative or friend will be paying for everything or most things, and that way you are not spending your life savings on a short visit for the purpose of tourism. And there's no need to put into the application form things which you cannot explain either if you're interviewed before the visa is granted or when you arrive in the United Kingdom. Make sure you have a clear plan, a clear vision, the time you're going to be staying, a return ticket, and you've discussed that with your sponsor, because if you're stopped at the airport here, they may call your sponsor to check whether or not you are a genuine visitor. And typically they'll ask you a set of questions and they'll ask your sponsor a set of questions. And if there are differences in the answers, that will probably result in a refusal. So once everything has been prepared, you should obviously get a solicitor or an expert to check that everything is as it should be, and then you submit them with a covering letter and explanation showing to the visa officer why you meet all of the requirements of the visit visa rules. If you applied for a single entry visa, a 6-month visa, that's all you'll get. If you apply for a multiple entry visa for a longer period, then that is what you'll probably get. If you're refused, then you can try and get the visa officer to reverse their decision. But if that is not successful, then your only remedy is to go for what's called judicial review. Now, that's not an appeal. And judicial review, the best result you can get is that the decision refusing your visa will be reversed or quashed by the court, and then a new decision will be taken. You cannot bring new evidence in except to answer allegations of dishonesty or anything to do with the documents not being genuine and so on. So you cannot start adding extra evidence in court proceedings which was not before the visa officer. And that's why it's important to get all the evidence in the beginning and all the explanations and the discussions and the arguments that you want to be heard, because judicial review proceedings can be very expensive. And if you lose and you are ordered to pay the costs of the Home Office, if you don't pay those, then in future applications, they will use that against you. So by way of a story, just to conclude, I recently concluded a case where a client of mine, she'd applied for a visit visa to come to the United Kingdom. That had been refused. And then we wrote to the Home Office, the visa officer, and said, we will take you to court if you don't reverse the decision. We didn't get a response in time. And when we eventually notified them again that we were going to go to court, and we did actually issue court proceedings, they then settled the case with us. We succeeded. The decision was withdrawn. A new decision was made, and the visa was granted. And my client secured the costs of their judicial review claim as well. So it can be done properly. It can be successful. Of course, cases can also fail. But the key thing is to do things properly at the first time of asking. And hence, it's important to get somebody to represent you, somebody who's a professional, who knows what they're doing, who can make sure that your application stands the best chances of success. That's a short overview of the visit visa rules. And of course, with hopefully the country opening up, you may well be able to invite your relatives and friends and family members to visit the United Kingdom. So take a good professional advice, and hopefully you'll be able to meet your family and friends and relatives this summer who you could not do in the past summer. That's all for me for now. What we'll now do is we'll go to another area which is linked similar to this, family reunion, because many families or people who come here as, for example, refugees or asylum seekers, they need, after they're successful, to try and bring their families over. And we'll take a short look at this from my colleague Rahil Latif, and we'll explain what you need to do.
1, 2, 3. Hello. Today I'm going to talk about refugee status and family reunion in particular. When an individual has been successful in their claim for asylum and has been granted refugee status in the UK, they're in a position to sponsor an application by their family member to join them in the UK. A family member would, under the rules, be their spouse or partner or dependent children under the age of 18. For the purpose of sponsoring a family member, the refugee themselves would have to be over the age of 18. With regards to the rules regarding family reunion, there's some key criteria that has to be met in order for an application to be potentially successful. With regards to spouses, the key factor, initial factor, is that they have a valid marriage. Thereafter, evidence has to be provided that there was a subsisting relationship prior to the refugee leaving the country of origin, and that relationship has existed following his departure or their departure. For children, there's additional requirements in terms of proving the relationship between the child and the parent, be that a mother or father, and that child is under the age of 18, and that they are a part of the family unit, not leading an independent life, or are not married. For many individuals, this could be a straightforward process. However, there are difficulties that may have to be overcome, particularly for individuals who may be without documents, or undocumented individuals, which do exist in various countries, or documents have been lost due to the position of the individual fleeing the country of origin, or due to war, etc., that has taken place. Therefore, other means and processes would have to be looked into in order to prove the relevant requirements for this application. There are circumstances where an individual may wish to sponsor another family member, be it a dependent relative or an adult child. For dependent parents, for example, this is outside the rules, and therefore, on an exceptional basis, the embassy, considering the application, or the Home Office in the UK, may consider that there are truly exceptional circumstances which requires that dependent parent to join the individual in the UK. If an application is granted, then the parent will be given leave outside the rules, somewhat on an exceptional basis. Similarly, with regards to an adult dependent child, the requirements that have to be met again are that child is not married and is not leading an independent life, and given the age, either over 18, there will be a need to prove that that child is an exceptional situation that requires the discretion used in their favour. Now, we've dealt with a number of cases in this sort of category. Primarily, you're looking at females, women, daughters, who are between the ages of 18 and 21, maybe slightly older, and due to the cultural issues in the country that they come from, it would not be acceptable for them to be living alone or without a male guardian, particularly if their father is the refugee in the UK. And therefore, on an exceptional basis, if it can be proven that there will be harm, one, to the individual, or more importantly, there will be an unnecessary breakup in the family unit by leaving that adult daughter or child in the country of origin, this would be unacceptable and harsh on the individual, then the Home Office or the Embassy can use their discretion to give that child leave to enter on the family reunion rules. So they could be given leave in line with the refugee, or outside the rules, and again given some other leave to enter the UK. If an application is successful, then the family member will be given leave in line with the refugee status. So if a refugee has recently been granted refugee status, they'll get the full period until a time when that refugee has to apply for indefinite leave to remain under the set protection route. I can discuss that later. Or in circumstances where a dependent relative or adult child has been given leave outside the rules, they'll be given leave in line with the family member if it's less than 2.5 years, or possibly a maximum of 2.5 years. Now, what is important for the family member who been given leave outside the rules, an adult child or the dependent relative or parent, is that they do not have the same refugee status as the refugee. They're given leave outside the rules, and therefore any future application will require them to make some alternative application under their immigration rules, possibly on a discretionary basis if the circumstances remain the same. Once the family members are in the UK, they have the same rights as the refugee, although they cannot then go and sponsor any other individuals from abroad on the basis of being a refugee. Their leave will be in line with the refugee, and normally refugee status is a maximum of 5 years before the refugee is entitled to apply for indefinite leave to remain in the UK. And at that time, when the refugee and his family are ready to make the application for indefinite leave to remain, all family members that came on the family reunion basis to the UK can join an application, even if by this time children who were under 18 have now become adults. And I would say that that's the recommended procedure to do so, for ease of the application process and for peace of mind for the family members. So that's just in a nutshell the issues regarding family reunion. And if there's any questions, we can go into further detail regarding the intricacies or difficulties that individuals may face. As I mentioned before, those individuals who may be undocumented and not have any evidence of their marriage.
Welcome back. That was Rahil explaining to us earlier on the law and the practice of family reunion. Now, my colleague Adnan Mahmood couldn't make it today for the issue of financial remedy, so I'm stepping in. With regard to financial remedy, this is also known as ancillary relief. This typically accompanies a divorce or between a married couple or a partnership when they end. So when a couple who've been living together are parting ways, there will be many things that need to be resolved in terms of assets being distributed and so on. So ancillary relief can be made at the time, the application can be made at the time of the divorce, or it can be made afterwards, but it makes sense, particularly if there are children involved as well, that you actually deal with the process all in one go. So how does this work? Well, typically one party will make an application for ancillary relief, and you will issue what's called a Form A from the court. Once that form has been issued, with COVID, things obviously are perhaps a bit more elongated, but usually between 12 to 14 weeks after issuing the form, there will be an appointment. The form has to be, the first appointment will be arranged. And whilst that is happening, you also need to do what's called exchange statements, sworn statements, i.e. that statements are truthful of financial circumstances. This is known as Form E, where both sides complete and list and document all the assets and income, etc. they have. And you need to provide, for example, all bank accounts, building society accounts, ISAs, TESAs, etc. Anything where you have a financial interest. Obviously, a valuation showing how much your property is worth, preferably in the last 6 months. A copy of the most recent mortgage statement showing what's outstanding. Your most recent P60 and the 3 most recent pay slips. A summary of any liabilities, what debts you have, loans, particularly loans to banks, which are hard loans, you could say, and then soft loans will be loans to family members and friends and so on. And what entitlement you have to a pension, because some pension pots are very, very sizable and they will be relevant to how they are going to be apportioned. Now, parties can deal with this by way of negotiation amongst themselves, because if both of you trust each other enough on terms of the information and know enough about each other's assets and income, it may be that you will save lots of money. Certainly, we will not make as much money. The only winners in these sort of cases are solicitors, courts, and experts, if they're proceedings which are drawn out. But if you cannot resolve this matter, you've disclosed the information that's needed. Now the matter will go to what's called a first appointment, where the judge will look through the information and deal with the issues that need to be addressed when this matter has to be resolved. The judge may well direct that further documents be disclosed. So if you think your partner or your husband or wife are not being honest or being economical with the truth, you may say to the judge, well, I want X, Y, and Z disclosed. I want him to do X, Y, and Z. I know that he's got something offshore here, there, or everywhere. So whatever information you want considered, your solicitor or your barrister will put that to the judge. The judge will take a view, and the judge will then give further directions. Then usually the judge will fix what's called a family dispute resolution hearing, because hopefully all disclosure will have been made, all directions will have been made where parties would probably indicate we can comply with all of this, and therefore the judge can be confident that the next time of asking, there will be what's called a financial dispute resolution hearing, and everybody will walk away knowing what they are entitled to take with them, i.e. shares of the property, if there are children involved, because children's interests almost always take precedence. Once children have been catered for, then the parties' interests are looked at by the court, and the court will look at all relevant factors in coming to this. In terms of the particular issues to bear in mind, there is a checklist. The court looks at everything that is relevant in coming to the conclusion who should get what. It's called Section 25 of the Matrimonial Causes Act 1973. And the court is very clearly interested in fairness. It wants to make sure that the assets are distributed fairly. And in those circumstances, the judge looks at the needs of the family members. it will look at the children's needs in particular. They come first, and then the needs of the partners. For example, one of the partners, or if it's a husband or wife, whoever gave up a career to be a homemaker, then that's a very important factor, because the court will look to see that is something which they've sacrificed for the purpose of the marriage, and they should be fairly and adequately compensated. You may have circumstances where both partners were working, but the money was invested by one partner, and now there's a dispute as to whose money it was or on what basis it was given, and hence what should happen to that in terms of the overall pot. That will be looked at. And so on. There's a long list of factors the court looks at. And ultimately, the court will also look at things like the age of the parties, the partner who perhaps is older, they will have less of a working life to earn anything, and so on. And so the court, having a regard to all of the circumstances and facts, will then make an order which will be for the distribution of the assets of the marriage or the relationship. And then after that, it will be a matter of enforcement. So that's a quick summary. As I said, I've stepped in for my colleague today who wasn't feeling very well, and hence this is where we're at. So now we're going to come back with all of us and just take a few moments to go through a few matters. Right, here we are. We're all back and, oh, sorry, that's the better way of doing it. So that was a short summary of ancillary relief or family remedy. So I'll come into you with regard to capability and employment. Now, when there are borderline cases, an employee doesn't want to leave and then thinks that the employer is basically using it as an excuse, how does an employee try and deal with that if you're fighting a big company, let's say, you've got on the wrong side of your manager or manageress? How would you, in your professional expertise, address something like that to try and get the poor employee, so to speak, a fair hearing and a fair crack at the whip?
Yeah, that's a good question. Look, any borderline cases, by their very nature, are going to be complicated and difficult to deal with. And sometimes by their very nature, because they are borderline, whether the employer makes a decision to dismiss or no decision to dismiss, either one could be right because it's so finely balanced. But as an employee, I've set out the factors and the procedure that the employer has to follow. So what the employee has to do is to show that either those factors weren't taken into account, and they should have been because they were crucially important, or the fair procedure wasn't followed. And again, the mistakes in the failure to follow the fair procedure meant that the whole procedure was unfair, and so the dismissal was unfair as well. But as an employee, you do need to find what I would say vital or crucial mistakes made in the process, rather than just nitpicking and finding minor errors which were made, which may have not made any difference whatsoever.
Okay. Right. I mean, in terms of the employee, what would you say that, because a lot of people try and plow on and deal with it themselves, whereas would you say that it will be recommended or perhaps necessary that they get a competent specialist solicitor to take a look? Because if a firm response goes back to the employer and the employer realizes that, look, there's somebody who knows what they're doing on the other side, we've been rumbled, so to speak, that they may well back off, or do you think it wouldn't make a difference in the generality of cases?
No, I think definitely, but because any issue regarding capability by its very nature can be complicated, always best for the employee to seek legal advice. As I said in my talk as well, when we look at capability, we sometimes touch on, or we go into the realms of conduct, which then makes things more complicated. We can sometimes then go into the realms of being a disabled person or disability. That makes things more complicated, and different laws then come in, different factors to be considered, different procedures apply. So if you're an employee who's faced with a situation where they are sick and the employer is trying to make a decision to dismiss them, or they think that's going to happen, it's always important for them to seek proper legal advice, because you never know, if their sickness amounts to a disability, then other laws could be used to try and help them.
Okay. In terms of the family reunion, Rahil, you mentioned typically it will be a nuclear family or a family of wife or partner and children. But in the case of adult boys and girls, you mentioned that typically with female adults, that's normally possible. Is it not so the case with adult males, say from the Middle East, for example, or the Far East, if the family is here as a refugee? Will that be not possible or not as likely to succeed? And if not, why not?
Yeah, I think it's, as you mentioned, it's a cultural issue. So we'll find that most refugees come from, well, we dealt with Middle East, Africa, subcontinent, Asia, and there's a cultural issue there where there is a difference between girls and boys. The local embassies are aware of this, and they will take into consideration that dynamic where an unmarried girl, regardless of her age in terms of 18, 19, 20, 21, maybe even older, may be vulnerable in those societies compared to a young man, boy of that similar age. And therefore, it is a case-by-case consideration. I mean, I've had a recent case where we've got two young sisters. One is under 18, one is just over 18, but the Home Office have decided to refuse their application, which we're looking to appeal if possible. But it's a case by case consideration. But as I said, the cultural dynamic is at play there.
Okay. And in terms of the maximizing your chances of success for adult dependents, would you recommend that they try and get some sort of expert evidence, or do you think any evidence, also expert evidence, will not make much of a difference?
It depends on the circumstances. As I said, I think an adult a relative who's not a parent, it will be extremely difficult to come under the family reunion rules. A parent, there is some other routes for sort of adult dependents to come through or make an application. For parents, again, it depends on the actual facts on the ground. What is the circumstances? Even for as I said, the or adult children. So. Is the parent dependent on the refugee? Is that parent a single parent in terms of their widow or widower? And have they relied upon that individual who's a refugee in the UK for their care and upkeep for a long period of time? So there's that issue of being intertwined in that family unit, and will be at disadvantage if they're left behind in their country of origin.
Okay, so moving forward, Saad, with you, let's say that you can't resolve the dispute with the employee if you're an employer, and effectively the dismissal does take place. How best do you try and succeed on an appeal to the tribunal, to the court, in terms of to prove that what's happened is incorrect? Would you then, let's say they came up with an explanation that you're not capable because of whatever reason, how would you seek to challenge that other than by saying, yes, I am capable? I mean, a judge would need some sort of convincing evidence, right?
Yeah, exactly right. So let's look at it from the point of the employee who's been dismissed and thinks that the dismissal was wrong in law because it was unfair. So as I said in my talk, they should have received a letter from their employer setting out written reasons why they were found to be incapable of doing their job. And then they can make their claim in the employment tribunal. And what they would have to show is that when the employer decided to make the decision, either they didn't take into account the correct factors, or possibly they took into account the correct factors but applied them incorrectly, or they didn't follow a proper and fair procedure when deciding whether to dismiss the person for reasons of incapability. So you'd have to highlight flaws in the decision-making process and in the procedural aspects of making the decision to show that the dismissal was therefore unfair in law. And if the tribunal agrees that there were defects in the decision-making process or in the procedure which led to the decision, then they can find that the employee was unfairly dismissed for reasons of capability, and obviously then the employee will be entitled to compensation or possibly even some other kind of remedy.
Okay, I was going to ask about remedies. So let's say you go to court, you win. Would you be able to get a reinstatement of your job? Or if that's not possible, then So let's deal with that first. Would you be able to get an order reinstating you to your job?
Right. So when an employee claims unfair dismissal, there are three potential remedies which they can ask for, which they typically try and ask for. One is called reinstatement, one is called re-engagement, and one is compensation. So let's take them one by one.
Yeah.
So reinstatement is when you effectively ask for your old job back. Re-engagement is where you want to go back to work for the same employer, but not necessarily in the same job because it's no longer available. And compensation is compensation. Practically, reinstatement and re-engagement is extremely difficult to obtain. And sometimes, even if you succeed in getting an order to be reinstated or re-engaged, then the employer can argue that there's been a breakdown in the professional relationship between the two of you, and therefore they shouldn't have to reinstate or re-engage you, and that can defeat any order that may be made by the tribunal for reinstatement or re-engagement.
Okay, thank you. Right, let's go back to you. So family reunion application's been made. Say the husband, wife, and the minor children succeed. And the elder child is refused because they don't believe it's the child of the marriage, and they say, well, you're too old anyway. How would you go about trying to challenge that? What do you do? Is there a right of appeal? Do you have to go for judicial review? Do you reapply? What do you do?
There will be a right of appeal, and so the consideration will have to be made as to whether or not an appeal should be made or a new application, depending on the reason why it's been refused. So it does come down to case-specific issues, but in some cases, like recently, as I mentioned, there was an issue where there was a period of time where the parents and younger siblings have left the country of origin, and there's a 3-4 year gap where the older children were living either alone or with other family members, and so the issue arose that they were leading an independent life, or they were no longer part of the family unit. So here again, we would have to look at the circumstances, possibly a detailed witness statement from the parents in the UK, possibly an expert report to look at the circumstances of those individuals if they're left alone, and statements from the family members who may be living in the country of origin to explain why they're not in a position to provide any support on a long-term basis, and that in the situation of young women, why that would place them in a vulnerable situation, and therefore be necessary for them to join their parents or parent in the UK.
Okay, so basically what you're saying is put everything in up front rather than merely ticking a few boxes, filling in a form, because many people think perhaps, well, look, I can do this, just a matter of filling in a form and telling them this is my child or my nephew, because in some cases, extended family members, if you're in a war zone and your niece or nephew has been orphaned, for example, they'll be living with you. So the answer there is that get somebody who knows what they're doing, assesses your case properly, completes the application forms, and prepares all the supporting documentation as to make sure that it's a strong application addressing all relevant factors. Would that be the better way to try and avoid refusals, which you then have to sit in or wait for months before you get to a court, or possibly years?
Yeah, certainly I agree, and that's the important point, that if you do get a refusal and you've missed out any documents, but then you decide to appeal for whatever reason, then you're looking at before COVID at least 9 months, maybe even up to a year to get into court. Now that process has been affected. It could take longer, and that could also undermine any future application if you decide to change your mind. So yeah, it's best to look at the circumstances, get all the evidence up front. Obviously, you got to look at not to contradict any information that's been provided before as well. That could be important. Just look at what the refugee themselves have explained in their original claim for asylum.
So you raise a very interesting point. I mean, where there have been previous applications and somebody has to get hold of the previous file and to make sure that if there are any inconsistencies or if there's anything which was not properly explained, that's properly addressed, and hence the need that first time of asking to make sure. In most cases, I would assume you're dealing with people through the medium of interpretation, and therefore you need somebody who can clearly and eloquently summarize and explain what's going on, so as to ensure that a clear application is made with all relevant information being put to the visa officer, who would then hopefully accept your argument that this person, even though they're not a child, should be granted a visa to come with uncle, auntie, or whoever else it may be.
Yes, that's right. I agree with that. I think this is very important nowadays because of Brexit. I know that a lot of individuals were relying on the Dublin Regulations 3 family reunification process, where their family member would make it to a European country, invariably Greece, that has been the case, and then come over following an application via the UNHCR. However, with Brexit, that process is no longer open. So now everything is going back through the family reunion rules, and that's why it's very important now to really look at this in more detail.
Okay, so Saad, finally coming to you. In terms of, people, when you talk to people about employment law, any law, they think cost. Oh my God, I can't afford to take a big employer. I'm the little man or woman in the street. In terms of funding arrangements to help people along, I mean, for example, if somebody has an insurance policy which covers legal expenses, would that be open to people? And what other funding options are available? And also, in terms of costs, could you touch upon that a little bit for any appeal hearings?
Yep, certainly. So, first and foremost, anybody is free and available to approach a solicitor or a legal expert regarding employment claims, but obviously there are charges associated with that. So it's always helpful for anybody who's potentially thinking of bringing a claim to look at any insurance policies that they have, such as home insurance or car insurance. It does sometimes happen that in a home insurance policy, they do provide cover for claims for unfair dismissal or sometimes discrimination claims. So if somebody checks their policy and finds out it includes cover for one of those claims or potentially both of those claims, then they'll be covered under their insurance policy, and their insurer will provide them with a solicitor. Outside
can
of
I stop
that,
you there for a second? Can I stop you there? If your insurer says go to a particular solicitor, presumably you have a choice. They cannot unreasonably restrict you from going to a solicitor, or can they compel you to go to a particular solicitor?
well, my understanding is that the insurers will have their own solicitors available, and they will direct the person to those solicitors. If a person wants to instruct a different solicitor, they can ask their insurance company for permission to do that. But I think it's more or less at the discretion of the insurance company.
Okay, that's useful. You were going to say something else.
Yeah, so I was saying outside of insurance, there are a few charities and organisations that will help people sometimes for free. They're not common. You do have to look for them, and sometimes they have referral processes and things like that. They won't necessarily take all your cases on. Outside of that, then you can always represent yourself. You are also allowed to take somebody along with you to the hearing as what we call a Mackenzie friend, who may know more about it than you, and they can assist you as the hearing is going on by whispering in your ear and telling you what kind of questions to ask and what to say and things like that. But I wouldn't say anybody should be put off by exercising their rights, because these rights are provided to everybody by law. Everybody has the right not to be unfairly dismissed. Ultimately, the legal experts will be able to assist them the best, but they should be aware that there are obviously other options available to them.
People sometimes are very worried that they'll have to end up selling their house to pay a solicitor to fight their case for them. Now, if they come to you, for example, and you assess the case, can you offer fixed fee arrangements? Can you offer some sort of clear quotation rather than an estimate? If you know the case, you know the details, so that they will know that it'll cost them 5,000 or 2,000 or 10,000, whatever it might be. It's difficult to predict exactly, but is it possible to give people clarity once you have been able to assess the merits of the case? The other side have responded to your letter of claim or your letter of complaint, so that people can make an informed decision in a confident way that they're not going to end up getting a very, very, very high unexpected legal bill.
Yes, exactly. That is something that we can do and something that we do offer, but only once we're able to properly see how much work is involved. And then we can say for a fixed fee, we will do A, B, and C, for example. And then it's obviously up to the client if they wish to accept that.
Okay. Well, Rahil, Saad, thank you very much for taking your time out and joining me and explaining some very interesting and complicated points in a very simple way. As ever, the live stream is up for everybody to watch. Please do share it with other people. And just to remind you again that all advice or information given is for guidance purposes only. Please do not act upon this to litigate your own cases. And the firm, Aman Solicitors, obviously disclaims any liability should you get something wrong, because like with anything where you need professional advice, professional assessment has to be made of the facts, and then the law is applied based upon that professional assessment and evaluation, which cannot be done by usually lay people. And therefore, you're always advised to get independent legal advice, professional legal advice before you do anything. And we thank you very much for watching. And we ask you, as I said, to give us comments and feedback on things that you may wish to have covered in the future. And we'll try and do that. And until next week, thank you very much. Assalamu alaikum from me and goodbye. And Rahil, Saad.
Assalamu alaikum, everybody.
Okay, and just bear with me for a second. You too.